a girl's court documents that just said that she was going to dox me sitting on my bed in my robe with my bonnet on and a mic talking shit.
I wish I had my bonnet on
while
right now.
My husband is asleep next to me.
In my
Let me
Taylor,
paint you that little picture.
My Taylor Swift cardigan.
For real. I'm not bored.
Let's see.
Are you not entertained?
Are you not entertained? Am I boring you, Courtney? Am I?
Miss Courtney, am I boring you?
And then just to comment briefly on the representations about the case, I think there is a distinction that counsel is overlooking, which is the conduct complained about by my client is the respondent, Miss Olson's direct statements on social media. This is not what her followers are doing. This is where Bree has trouble understanding. This is not what she is saying in a private chat. And my understanding, and I admittedly am less adept at social media than both of the parties, but my understanding of Discord these are private messages and private channels. And so I think this would be akin to subpoenaing my client's private text messages. If we're going to open the door to the use of the party's private conduct being used for a restraining order when it's not broadcast publicly, there's no actual public or overt incitement of anything. Incitement, that's an interesting word. It's almost like that's what Bree does. I think we will probably respond similarly. And as for the respondent's Discord records, I don't think this is necessary. I think we can streamline the issues in this case by focusing on what the parties are actually saying, not what their followers or supporters. And frankly, we don't even know if these are supporters or haters. Not saying haters in court.
So she's saying, oh, we can do this even though we don't want to. We can do this.
Yeah, she's like, if you want to do this, let's fucking go. That's basically what she's saying.
That's what she's saying. She's saying, well, if you want to take this route, we can take this route. I don't want to because my client may get caught up. But
in our terms,
take this route with yours.
Yeah, she's basically like, you really want to do this, bitch? She's basically saying the same thing I am. Send that cease and desist. Let's fucking go. Let's see. Where was I? And frankly, we don't even know if these are supporters or haters. These are random people on the internet that have gotten, for whatever reason, involved in this case. I'm glad she recognizes us. That's so nice, Miss Budnick. And I do see that as an issue, as an offer of proof. Wait, can I stop you for 1 second? Yes. And maybe it might. I'm so glad you both have counsel, Mr. Giese and Miss Olson, because this case, I believe, raises a number of potential First Amendment issues, and we're kind of new in new territory. I'm familiar enough with TikTok to be dangerous, but I don't know, there are, I've heard of Discord, but of course I don't use it and I don't know enough about it. I am familiar with TikTok, but the bigger issue it's much of what's been.
This is crazy.
But the bigger issue is much of what's been referenced back and forth is comments either about each other or about the child, and or comments or either postings or comments in the comments or other comments by third parties about another party.
Live, weirdo.
Who is it? Kara? Okay, Kara, it was nice.
Stop.
Hold on, y'all. Watch this. It was nice knowing you, Kara. Kara, let us sing you out.
It's closing time. Kara's got to go. It's closing time. Kara's got to go.
We'll see you later, girlie. You have a nice time. See you later.
Deuces. Okay. Keep
All
going,
right,
girl.
back to
Sorry,
it.
we had to get rid of some.
Okay, so back to the comments of the comments and the other comments. And then we have the old issue. Yeah, Kara, are we boring you?
It's my new thing.
And then we had the old issue with they're not even subject to this court's jurisdiction, those other people, because they're not before me, and I don't even know where they are. And then there's the issue of, it's my understanding both of your clients make their living through social media. And from what I can tell from the declarations, not only do they make their living by social media, but they make their living right now, at least through social media, in the context of their roles as parents and talking about baby W. They both talk about baby W, whether good, bad, or indifferent. They both talk about baby W. And it sounds sounds like from their filings that their followers talk about Baby W. So
Baby
I
W.
admit, I think I have a little bit of case law to guide me, but usually that's in the area of when one party either uses social media to directly contact someone else, or they, go into someone's private, like in the Evil Sizer case. That's the case that we've read and referred to before, y'all, that I read to y'all. Yeah, it's actually kind of interesting. In that case, it was a domestic violence restraining order, but the issue was one side went into the other side's private photographs that were embarrassing and then revealed those publicly. Oh, God, not the private pictures. This is a different situation, and this just raises a whole host of First Amendment issues, and that's why you'll see I was very careful in the original restraining order request, because I was cognizant, that's a big word, Judge, for your little country self. I was cognizant of the potential First Amendment issues, and it's not appropriate for me to raise those sua sponte, I don't know how you say that, on Miss Olson's side without counsel. Oh, so they didn't do it because she didn't have counsel yet. Other than to identify that there are potentially issues here. Thank y'all. And so I'm glad that you were both here, because my sense is you're going to brief those issues for me. That being said, that's why, Miss Phonics, I am uncomfortable at this juncture with respect to the oral request, and I agree with Miss Budnick, and I'm glad she said it. Hold on, y'all.
You see how Kaylee hears a kid? She stops what she's doing. She doesn't continue streaming. Very demure.
I think she was just rustling.
Very motherly.
What's it admitted? You admitted it on live. What did we admit on live?
Very mindful, yes. Very motherly. Very big
demure.
mama.
Very
big mama.
Yes.
Thank you.
Very cutesy. That's why, Miss Phonics, I am uncomfortable at this juncture with respect to the oral request, and I agree with Miss Budnick, and I'm glad she said it. I was more inclined to let you do what you feel you need to do in terms of serving subpoenas on third-party providers. I don't know who the parent company of some of these social media companies are, but let you do what you need to do and follow whatever laws if it's notice to consumer or whatever it is, and see either if there's an objection or if there's not. And if Ms. Budnick then files a motion to quash, but as you're all aware, 6309 can be very limited and the court has discretion, and it actually says a court may grant a request for discovery, and then it says only upon a showing of good cause. At this juncture, I don't know if I have that or not, and I think that implicates all those various First Amendment issues. So I'm comfortable, especially on an oral request, saying granting your request. I think the best place to start is let you serve whatever STDs you would tend to serve. Excuse me.
She's serving them up on platters now?
I didn't know they were serving those in court. Oh my. Oh
Keep me
my.
out. I don't want to go to court.
And if those are subject to litigation, I'll address those at that point. But I agree with Miss Budnick. I mean, I understand why it came so late, but to try and respond to something that I had just a few minutes to peruse, he likes that word, this morning, and then try to make a significant legal determination on that, I'm not comfortable doing. Just to be clear, the reason I was raising the request to issue the subpoenas in the first place, what?
Somebody said to the STDs, I beg your finest pardon. And then she just sent me to
your
Mars.
finest
I'm sorry.
pardon. We don't have valet stuff. What do you mean? We can definitely look at her stuff too. If you find it, send it to me. The 6309 prohibition against discovery with a restraining order in place. Now we all know this is not a traditional RO. The only box that is marked is the order not to abuse. But I did not want to be viewed by the court or by Dad and his counsel as trying to circumvent the rules, because there is still a type of restraining order in place. So since that is true, 6309 requires the court's permission. Now, if you're going to say, well, you don't need the court's permission to do a subpoena for the production in court and for the witness to appear in court, yes, that is true. And we would also be doing that type of subpoena to Discord. But we want the, I guess, more normal subpoena, the deposition business records subpoena, where we can get the records in advance of the court hearing. Then we would do the other subpoena separately to have their custodian of records produced into the court. So that was the only, I guess, order I was actually seeking, was the court's permission. Again, treating this as a traditional RO case, even though it's a non-traditional RO that's in place, because that's what the law says we have to do, is we have to get the court's permission to do any type of discovery except for the, trial appearance subpoena. Miss Budnick says. And just correct me if I'm wrong, Your Honor, but my understanding is the court isn't making a determination that she can or cannot do this discovery yet. She can attempt to serve the discovery. I can raise whatever objections or issues I want in a motion to quash, and then the court will hear it in connection with whatever motion I file. If we oppose the discovery, we may allow it. That's exactly what I'm saying. Thank you. I'm just not in a position to say either way because I'm not prepared. And I just received the information today, and I think there are a number of novel issues that are raised here. I look forward to reviewing your various filings in that regard. All right, so now we need to address so let me ask you this, I think it's Miss Budnick, because wasn't it Mr. Giesey's move away request? He's the moving party in both of these, is he not? Yes, so we're kind of in an interesting position because he had filed a move away request. We had started a 3-day. We had 3 days of an evidentiary hearing, and then halfway through that hearing, we ended up entering into a set pendente light orders. I haven't heard that before. To allow the move to give my client primary custody in Texas. So Baby W has been living in Texas since November. Our hearing was October 31st, so November on. He has actually already been in Texas. So it's kind of at this point, I would say maybe a reverse move away. The child is already there, but we're determining, I guess, if he should come back to Los Angeles. I'm not positive that if that's what respondent is requesting at this time because she has not had counsel and it's a little unclear to me what she is seeking. So I think a continuance with counsel involved now and the ability for, God, they just like make her sound so dumb because they're like, she hasn't had counsel this whole time. Involved now in the ability for a respondent to provide briefing would be very helpful for myself as well. So I did a brief just based on the move away factors and I kind of treated it as he's already here. This is why he should stay, but I don't know if that's even the appropriate analysis at this point because I don't know if the respondent's issue is the child remaining in Texas or if it's the monitored visits. So I would benefit from additional briefing and whether we treat this as, a move away to Los Angeles at this point or if the issue is more just timeshare. The court. Miss Phonix, do you want to respond? I think I wrote it out kind of a Brianna's goal in the DV-125, and I understand that everybody might not have reviewed that full packet yet, the one that was filed alongside my declaration yesterday, but ultimately the goal would be shared custody. We don't have any information that the parties are going to be living in the same city anytime soon. My client understands that she's going to have to work her way up from the bottom. So basically this means this kid is not leaving Dallas, just to be clear with all of y'all. Who'd we lose? Hillary, hold on. Let me play a song for you, Hillary.
Oh, did she get blocked off of me? I blocked her.
Oh, did you? We'll see you later,
blocked her.
Hillary.
I don't know if your mods had her. I did it.
Dang.
So I don't know if it blocks on my side too.
It did. Miranda said she did. That's funny. Well, she say something about me being a nurse? What a dummy dumb.
Miranda, I'm going to mod you if that's okay.
What a dummy dumb. You won't be missed. See you later. Miss Phonix is Bree's lawyer. Budnick is 2K's lawyer, and the adorable country southern man who wears boots with the spurs is the judge. To get an arrangement like that. And right now she's on supervised visits, so she understands that it's going to have to be supervised. Bree understands, y'all. That is her name from now on, Miss Phonix. It's not, but it's her name now. Judicial assistant. Oh, Lord, she done told her. She said, slow down. Oh, yeah, I'm sorry. Yeah, slow down. The witness? Who the hell was the witness? Yeah, graduating to unsupervised and then eventually what we would label as a normal schedule, as normal as can be when parties are living in two different states. So eventually her goal would be something like what they shared before under the stipulation and order, but something that's more 50-50 and something that involves less travel back and forth. Because the back and forth for the whole family collectively, I think of doing this once a month, twice a month, or once every other month was a lot. So eventually if the schedule could look something like Baby W is in LA for 2 to 3 months with mom, then Winter is in Baby W, sorry y'all, is in Texas for 2 to 3 months with dad, something like that. But obviously we can't see into the future. We don't know if dad will ever live here, if mom will ever live there. Counsel and I have not talked about this particular subject matter in substance because we can barely agree on anything to do. Is this her? Why does it say the witness? This has to be her, because that's insane to think that a child would ever fucking be able to do that type of arrangement. Anyways, to do with the we can barely agree on anything to do with the supervised visits. So like she said, we have not briefed this issue since I've been on, and I've only been on this case, oh yeah, this is her, for 2 weeks now. But yes, this will definitely, see, she was speaking too fast. The court reporter done wrote her down as a damn witness. This will definitely be something that we will need to brief and talk about before the eventual trial date on all the issues. Yeah, what you mean is your client's going to end up having to agree to whatever John wants because your client's a dingaling. Anyways, no, it was her lawyer. They just wrote it down wrong. Okay, well,
yeah,
let's.
Somebody said we can't even agree with your client is wild. Yeah, that is probably so. Our assumption that the lawyer,
trust me, y'all, the judge is very aware that Bria's the problem. Like, just going by this, and I've been in court before, like, very aware who the problem is.
And just by just with the lawyer, talking too.
Yeah. Oh no, that was her lawyer. Okay, well, it was called a move away. Then you settled it, sort of. But then you kind of moved away from the move away. And I think we should start with the premise as a move away, but it can also be a move away custody and visitation. I mean, as you all know, you've been doing this a lot longer than I have. If someone has soul, it's a lot easier. The standards are a little bit different from the move away than if it's a joint. So I think they're interrelated, but we have a lot of steps to get to before. And I know just for Miss Olson and Mr. Geese's benefit, you're hearing a lot of legalese from all the lawyers and the judges talking. And I know you're both relatively young and you may not, just to sort of let you know what we're trying to figure out is, damn, they're treating them like they're idiots. Figure out is the restraining order, the restraining order, B, what works best from custody and visitation. And look, there were a lot of allegations back and forth, and I recognize you were both young, and I recognize you both make your living in a totally different way than this court does, which I'm totally off of social media and off the internet. This judge is like, please don't find me. Please don't let your following find me. Please, God. I'm totally off of social media and the internet, and that's how you all make your living, so I understand that. But it sounds like there are allegations back and forth from certain things that have been said, and baby W being taken and baby W not being returned. So the judge is acknowledging that the baby was taken. An allegation of bad influence around and all of that. And just so you all know, my main interest is what's best for baby W. And so that's what I'm trying to get at. You know, and as you all know, and as I'm sure your attorneys have explained, the family code recognizes, especially with small children, is that it's best for them to have what they call frequent and continuous contact with both parents. And that is true. That is what most courts believe, y'all. That's just that's what they want. They think, and like he says, especially with small children. So, yes. And so, you know, in a perfect world, long periods of time separated from each parent is not particularly good for baby W. And regardless of the drama between the two of you, it's clear to me you both love your child. Well, hell's bells, Judge. I'm glad you could tell us. You both want to be with your child, and your child loves you. Judge, you don't know that shit. You ain't seen that baby. And so we have to figure out a way that works and do what the lawyers are trying to do. Let's get some dates first. Baby W. It's like, you know, George W. George W. Bush, baby W. Let's get some dates first. We really don't have any dates, unfortunately. My court calendar, nothing in July, right? We're going to do something in the interim. Don't worry. I mean, I know my second part of my goal today is to address the visitation, the supervision, and all that. But at first, my sense is you both are going to have to be doing some briefings, some subpoenas, things like that, correct? They both say, yeah. Let's see. This is basically just him and the lawyers talking. Oh, wait. Nope, y'all do want to hear this.
So hard not to respond to people.
Who? What? In your chat or mine? Are we not joined?
I don't know. This girl, Amy, said, what does she think she's trying to accomplish by leaking these documents?
They're already out.
Yes. The fuck
we
are you
don't
talking
leak
about?
the things. We just find them or they're sent to us.
Did somebody ban her? Because I'm going to play her song. Mods, ban Amy. Amy.
She said she meant Bree. Okay.
Oh, sorry. Not Amy.
Wait, bring her back. Bring her back.
Amy.
Sweep her back in. Sweep her back in. Sweep her back. I take it back.
I'm sorry. I'm sorry.
How about no?
Sorry. Oh, that was on me. I'm so sorry. I'm so sorry. If you are a sub and you are in my Discord, you get access to these documents. They have already been posted. Santos is banned too.
Santos. Everything that I have, praise the Lord.
Oh wait, we gotta have a celebration. What do y'all want to celebrate with? Hold up. I got us.
Oh my God.
Okay, everybody, we're having a celebration.
this bitch, yeah,
Ooh,
paid
is
in
that
this
what
bitch.
we need?
Ooh,
Oh,
okay,
hold up,
okay.
y'all. We're gonna have a celebration. I don't know, 2K.
Oh my God.
Is 2K
Can chat confirm? Chat
What's 2K
confirm.
on?
Chat confirm.
I need mods to confirm,
confirm.
please. We need a confirmation. We need a
Yo.
confirmation, please. Confirmation from Lay Chat. It's
Yes,
not.
he is.
Oh, damn.
Santos is not banned. What?
Juanito
Who
is
the
banned.
Fuck would say
Juanito.
that?
Wait, that's his real name?
Why would you say that, Dan?
Don't lie to me. Wait, AI text creator.
Be a
I didn't-
truther.
Be a truther, not a liar. Didn't y'all hear the judge? We was about to celebrate. What the hell is wrong with y'all?
Damn, y'all. Who did
We were
that?
so
Somebody
close.
got
Why
our
would y'all
neck
do that to
real good.
us? Why
Somebody
would you
got our
do
neck.
that? Not me
Damn
having to
you.
use
Damn.
YouTube.
Oh my God, look how fine that man is. Okay. Hold up, we might find Shelby.
Oh, good man. Good.
Shelly come running.
Okay.
The joint account is banned. Very uncool of you all to not tell the truth.
I know, somebody got our neck so good back there.
It's in a place.
Why y'all get our neck like that? I got beef.
Yeah,
Hold
who
up.
did that? That
Run
was
it.
definitely a Bree fan.
Run it. I
That
need to
was
run it with
definitely-
whoever.
That was definitely a Bree fan.
Dude.
We do a little trolling. It's called we do a little trolling.
We don't like trolling over here.
That was good. Whoever
We
trolled
don't
us
like
like
that.
that was good. That was good.
I hope you're excited for nothing. Yeah,
Right.
his hair
no,
is fabulous.
seriously.
I am jealous.
He do got better
I
hair than me.
am not a Bree fan. Okay, well, if he gets banned,
Jordan's in here.
Jordan who?
Jordan. 1-3, soon to be 2-3.
Please. Jordan. Also, I'm waiting for my paycheck. They said you're supposed to pay me,
Jordan,
and I feel
can you look
like
at your message requests?
I have not been paid, and I'm I'm reporting. I'm reporting
Jordan.
you.
Hold up. Can you look at your message requests real quick?
Can you please?
I'm trying to get something.
check those message requests, dog.
Yeah, hold on. While I
Sorry,
got
I'm
here.
broke. I fucking knew it. I fucking knew it, dude. God
Bree
damn,
scammed him.
motherfucker.
Fucking Bree.
Jordan, I'm gonna need you to pay me because I'm supposed to be getting a cease and desist in the mail, and I'm gonna
I
have to file
know.
some things. So, chop chop, baby, pay
Yeah,
up.
Jordan. We said if we get a cease and desist, we're wiping our ass with it.
Yeah. Please.
I'm physically poking a hole in the paper and wiping my ass with it, and then squeezing it off to get the
Listen,
shit
if your
and
card's
sending it
never
back.
declined at Target before, I don't want to be your friend. It builds personality, okay? It builds
It's
character.
characteristic.
It builds character.
character.
We've all had, when your butthole gets real tight because you don't know if your card's going to go through or not. Don't play with
Fuck
me.
that. Let's talk about the Target lights that make that they're fluorescent. They make your ass itch.
Also,
Every time
don't
you go into
forget,
a TJ
guys,
Maxx or a Target, I have to shit.
Times are tough. Y'all, Jordan has to move. There's a lot going on. Cut that man some damn slack. Cut that man some slack. Golly, y'all.
No, he did. Hold on. Oh my god,
It's
this
never
shit's going
happened to you?
So fast, bro.
I have definitely had my card declined before. I am not a Richie. I am a brokey. Broke girls.
I'm a humble hoe. Excuse
girls.
me. This card has declined.
Broke girl club.
Okay.
It's a lot of
Excuse
pages. It's
me?
like 80 pages of basically shitting on Brie.
I'm humble, babe.
Scroll so we can read. Well, guess what? No.
Oh, I know. Sorry, Anna.
Hey,
We have
if you
squirrel
want,
brains.
if you want me to keep going, you got to subscribe.
Oh, you're Oh, I was about to call you something that would probably get us a violation.
Ah,
He's a tort. Don't ca- Y'all,
we're all broke. Team broke in here.
I know, I'm broke
Team
as shit. Why do you
brokies.
think I'm talking about Brie?
Team brokies in here. I'm already subscribed though. Fuck. Okay, back to your programming. Let's see, where are we at? Okay, y'all want me to read this. So what are y'all thinking in terms of time? How much time would you need? I agree that 3 afternoons would be a good idea. I think given to the extent we are all going to be spending, and I don't know if we will, but if we spend a lot of time going through recordings of social media content that will take up a significant amount of the court's time, just as an offer of proof, the recording that I have of the incident where baby W was being withheld in respondent's home is almost 2 hours long. So I don't know that the court, man, that means that they probably got her stream. Do you think they got the body cam or the stream?
What do you mean?
Because she says where she withheld the baby was 2 hours long. Jordan, don't listen to this part. You did take accountability and you said you were sorry, but don't listen to this part because you were in on this, and I'm still upset about that.
Ooh.
Both. They got both. Oh, what do we get? We got a subscriber. We got 2 subscribers.